All right, thank you for joining us. I'm Dean Jessica Berg, and I'd like to welcome you to our inaugural Practitioner-Focused Conference on United States International Trade Law and Policy. The late 2016 and early 2017 period is shaping up to be particularly consequential for the future of U.S. international economic law. Trade issues, as you might know, were featured in each of the 3 presidential debates and have remained a source of political controversy for some time. Professor Juscelino Collares has organized a fantastic group of speakers to address some of these issues. Since joining our faculty in 2011, Professor Collares has made the case that U.S. law schools should reconsider how to prepare students for trade practice. He argues that because trade practice involves appearing before U.S. agencies and subject matter-specific federal courts, law students should be well-versed in both the administrative and procedural aspects of U.S. trade law. This unique approach, we hope, differentiates our students, as reflected in the type of conference he has prepared for you this morning. A graduate of Cornell Law School, who also has a PhD in political economy, Professor Collares is a Brazilian-born naturalized U.S. citizen, practiced law at Dewey Ballantine in Washington, D.C., where he litigated trade cases before federal agencies, federal courts, and NAFTA panels. He's also an accomplished empirical legal scholar and recently appointed to the Office of the United Trade Representative to serve on the United States roster of NAFTA Chapter 19 trade panelists. As I've said, he's prepared a very, very interesting conference for you. He'll be with you for the rest of the morning. I apologize, I will be ducking in and out of different things, but I think there's a wonderful group of speakers here for you, and I very much hope you enjoy the day. Thank you.
Thank you, Dean Berg. Thank you, students who came, and the other members of the audience. This is indeed a very auspicious time for discussing trade. I will begin with some brief remarks about the evolution of trade policy in the history of the United States, and then we'll open up with, we'll transition from there to a presentation of our guest for the first roundtable, for our roundtable with Judge Gordon and Larry Friedman, following these remarks. Okay, the 18th century world of George Washington, America's first president, was a much simpler yet incredibly harsh environment to conduct commercial and financial transactions. Merchants in Boston Harbor would write out orders in longhand and wait months for shipments to arrive from Europe, mostly from England. It then took several months for these goods to cross the Atlantic to their customers in the American colonies. Often the goods arrived damaged or defective, and there was little, if any, border inspection. Fortunately, lex mercatoria, the law of merchants, a byproduct of centuries of commercial and financial coevolution, offered some solutions to private parties so they could order their commercial transactions with greater judicial security and predictability. Often enough, however, lex mercatoria was powerless against the arbitrary deployment of mandatory law, whether that took the form of sudden changes in tariffs, customs reclassification, or unexpected demands for quarantines. Such arbitrariness, arguably motivated by parochial, well-entrenched third parties, will leave business parties at the mercy of foreign officials, against whom private remedies or the invocation of free commerce and navigation agreements, when existing, would provide delayed and mostly inadequate redress. In such circumstances, it is not surprising that George Washington assigned priority to building a self-reliant national economy with manufacturing capacity to support our military needs. He understood the importance of trade and the need for access to European export markets, but domestic manufacturers and a diversified industrial base came first. Yes, Washington conducted an isolationist foreign policy designed to preserve the nation's hard-won independence. He advised against non-reciprocal trade concessions, and Alexander Hamilton, our first Secretary of the Treasury, recommended a program of tariffs and subsidies to foster national economic independence. In our days, over 230 years after Washington's presidency, a different set of ideas and values prevail. Among the new American internationalist economic, political, and academic establishment, free trade is in, protectionism is out. Paul Krugman, New York Times columnist and economics Nobel laureate for his work on international trade, economics, and geography, provides a perspective that states that while free trade is generally the better policy, trade liberalization must take a second seat to the establishment of a robust social safety net, lest social and political instability begin compromising the mutual gains from free trade in the last decades. This is a view that I share. Without a doubt, present-day general enthusiasm for open markets and lowering of tariffs is a commonly held view among most scholars, regardless of their views on trade remedy law and customs law. The broad areas our distinguished speaker and later our panelists will be discussing today. This change in views reflects a pragmatic response by trade practitioners, business leaders, public officials, and scholars to a much more complex and interdependent world. The growth in market internationalism in the form of intermodal transportation, the internet, e-commerce, the IT revolution, the intensification and vertical integration of production, and the centrifugal effect of expanding multinational supply chains explain this unstoppable interdependence. Yet it would be simplistic to attribute the triumph of market internationalism solely to economic and technological developments, as if these developments were detached from political transformations. Rather, the tremendous change from protectionism, cresting in the 1930s, occurred largely as a result of a tectonic shift in government regulatory policy. This development largely resulted from a gradual and unswerving transformation in the deployment of presidential powers in the American Republic. Every president, from Franklin Delano Roosevelt to Barack Hussein Obama, has followed an import liberalization agenda, characterized by lowering tariffs and increasing market access for goods and services here and sometimes abroad. With the executive branch, not Congress, managing trade policy since the 1940s, the presidents have invariably ignored George Washington's advice against non-reciprocal trade concessions. These modern-era presidents, equipped with fast-track authority, now referred to as trade-promoting authority, have believed they must do so only by redefining the national interest. From Truman through Reagan, from Reagan through Obama, America's presidents have grounded the national interest on the adoption of policies that promote domestic growth while shaping market internationalism. Of course, they have done so with different fiscal policies or targeted approaches, each with different success. Or has it been the opposite? That is, has the shaping of market internationalism taken precedence over domestic growth or other measures of domestic welfare? That America's geopolitical priorities may conflict with domestic interests is thus not a surprise. The controversy over the Trans-Pacific Partnership often conflates these two goals. The recent presidential debates demonstrate how present-day politics has attempted to respond to the growing skepticism on free trade. Thus, the jury is still out on whether the accelerated pace of technological change and the push for greater economic interdependence can effectively create economic prosperity that compensates for economic dislocation and political alienation, particularly among the most vulnerable to global competition. Is the United States president, constrained due to his or her geopolitical alliances and the interconnectedness of supply chains, still capable of managing this complexity and thus in producing results advantageous to most Americans? Have they, the presidents, at least put the nation and the world on a course to meeting these challenges? Will the next president, aggrandized in today's republic, deal effectively with the trade challenges that have emerged? Each of our speakers today has struggled with these questions. We should welcome them and thank them for sharing their expertise and for making us wiser. Please join me in thanking them. We will now transition into our, of course, where are my tabs? Just a second. Where are my bios? Okay, we will now transition to Judge Leo M. Gordon, our distinguished speaker. Following Judge Gordon's remarks, Larry Friedman, President of the Customs and International Trade Bar, and I will proceed to a roundtable discussion with Judge Gordon. We will leave ample time at the end for questions and answers from members of our illustrious audience. I met, just a couple of things I have to say about Judge Gordon here. I met Judge Gordon over the phone in 2005. On a desperate call to the CIT, Leo Gordon, then clerk of the court, kindly answered. Patiently, over a number of days, he helped a nervous young scholar fill out missing data from commerce redeterminations by providing me those documents which had been archived by the ITA off-site. For those unfamiliar with Washington jargon, and I mean no offense to the Department of Commerce, the words off-site archiving is euphemism for this document exists. Now finding it is another matter. The data I obtained thanks to Judge Gordon's invaluable assistance helped me conclude my research on comparing AD-CVD rates, reversal rates, between U.S. trade courts and NAFTA binational review panels and extraordinary challenge committees. To date, my highest cited work. This work showed how international trade tribunals have undermined our trade agencies' faithful administration of our trade remedy statutes. They tend to reverse commerce and the ITC, the International Trade Commission, at twice the rate that our trade courts do. For the help in launching my career as a scholar on trade, I shall forever be indebted to Judge Gordon. Judge Leo Gordon was appointed to the United States Court of International Trade in March 2006. Judge Gordon's career is one dedicated to public service. His career began over 3 decades ago as assistant counsel to the Subcommittee on Monopolies and Commercial Law, Committee on the Judiciary, U.S. House of Representatives. In that capacity, Judge Gordon worked on numerous legislative projects involving commercial and antitrust law, civil and constitutional rights, and court reform. Most significantly, he was the principal attorney responsible for the Customs Court Act of 1980, the act that created the U.S. Court of International Trade and cemented its position as an Article III court. Following his time with the Judiciary Committee, Judge Gordon served on the staff at the court for 25 years, first as assistant clerk, then clerk of court, until his appointment to the bench. Judge Gordon graduated Phi Beta Kappa from the University of North Carolina, Chapel Hill, and he received his degree from Emory University School of Law. Please, let's give a warm welcome to Judge Gordon. You can sit there if you want, or you can... No.
Good morning, ladies and gentlemen. It is a privilege and an honor to be here this morning to deliver the keynote address at this inaugural conference on international trade law at Case Western Reserve Law School. Many thanks go to the law school, and in particular, Professor Yusolino Colares, for inviting me to join with other distinguished practitioners and government lawyers on this morning's program. My goal today is to share some insights on the evolution of customs and international trade law in the United States and the 35-plus year history of the U.S. Court of International Trade as a backdrop to today's discussions on trade enforcement and justice in changing times. If one takes a careful look at the history of customs and trade law in the United States, you can see the history of our country. Just start a mere 243 years ago, transport yourself to the spring of 1773, and the passage of the Tea Act by the British Parliament. That act created a tax, a duty on tea imported into the colonies. A scant 7 months later came the Boston Tea Party, and as they say, the rest is history. Having become a nation, the Founding Fathers included language in the Constitution in Article 1, Section 8, the very first sentence, pertaining to the assessment and collection of customs duties. Quote, "The Congress shall have the power to lay and collect duties, taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States." Close quote. This provision eliminated the old system of individual state rates. The importance of tariffs for our fledgling nation is seen in the Tariff Act of 1789, which was the first national source of revenue. The tariff rates were designed to generate monies to pay the national debt and sustain the annual expenses of the federal government. From then to the adoption of the 16th Amendment in 1913, providing for the income tax, tariffs were the primary source for funding the United States. A side note, we had this conversation last night. You want me to steal your thunder on the trivia question or no?
That's fine.
No, I'm going to let you
That's
ask the
fine.
trivia. There's a trivia question coming later on this morning. Protectionism in the form of high tariffs and free trade has always been a part of the American political landscape. In the first third of the 1800s, protectionism played itself out in the form of expansion and modernization of highly productive American factories, touted particularly by Northern industrialists. Protectionism, in turn, was met with calls for nullification and secession over high federal tariffs. These high tariffs were viewed as detrimental to the economic interests of American exporting interests, that is, the rural and agricultural interests of the South. This tension between the party of the high tariff, the Whigs, subsequently to become the Republicans, and the party of the low tariff, Democrats controlled by Southerners, existed until the Civil War. Generally, rates remained low from the 1830s through the 1850s, increasing significantly in the 1860s. Though slavery and states' rights were critical factors in the start of the Civil War, it is open to debate whether the tariff issue contributed to secession and the war. Some minimize its effect, while others ascribe it greater importance. As the Civil War became a major conflict, the federal government obviously needed vast revenues, which resulted in higher tariffs, particularly for goods from Europe, with rates approaching 50%. Now, after the Civil War, high tariffs remained, but the economic rationale for sustaining those tariffs was subject to great challenge. The 1888 presidential election, in fact, was fought principally over the tariff issue, with President Grover Cleveland, an advocate for the low tariff, being defeated. Interestingly, the leading advocate of the party of the high tariff was Ohio Representative William McKinley, later the ill-fated president. His efforts and that of the party of the high tariff culminated in the Tariff Act of 1890, which, among other things, established the Board of General Appraisers, a predecessor institution of the U.S. Court of International Trade. The board was an administrative body within the U.S. Department of the Treasury charged with giving full force and effect to the constitutional mandate of uniform and consistent treatment of customs classification and valuation decisions emanating from the different ports of entry into the United States. The board consisted of 9 general appraisers, with no more than 5 of the appraisers being from the party of the high tariff or the party of the low tariff. Now, a historical note is in 1890, 9 general appraisers. Today, 9 active judges on the Court of International Trade. The advent of World War I impacted trade patterns with reduced trade and the passage of the Internal Revenue Code. Tariffs faded in importance vis-a-vis federal revenues and political rhetoric. One last effort in the form of the Tariff Act of 1930, more commonly known as the Smoot-Hawley Act, was made to return to high tariffs as a viable model in managing the American economy and America's role in international trading. Needless to say, we all know what came of that. Post the Great Depression and World War II, there was a concentrated effort among nations to liberalize trade by minimizing tariffs and address other restrictions in the form of non-tariff barriers. A small but significant part of this history is the important role of judicial review of challenges to the administration and enforcement of the federal customs and international trade laws. Congress, for the past 125 years, has responded to the complexities of the commercial marketplace, the needs of participants in the trading community, and the desire for greater transparency in the decision-making process. In so doing, the Board of General Appraisers evolved from an administrative agency to the Article I U.S. Customs Court, to the Article III U.S. Customs Court, and eventually to today's U.S. Court of International Trade. With this background, let me turn to the saga of the Court of International Trade. The prologue is simple, yet powerful. In the 60s and 70s, it is the 1960s and 1970s, and the community of nations is growing ever closer. It is becoming increasingly apparent that the language of trade is becoming the language of foreign relations. There is great interest in having the framework that governs the peaceful resolution of customs and trade disputes be responsive to the needs of the international trading community. First comes the Customs Modernization Act of 1970, then the Trade Act of 1974, followed by the Trade Agreements Act of 1979. The latter was enacted by Congress to address substantive concerns about the shortcomings of the federal international unfair competition laws and to implement the international accords reached at the GATT negotiations in the Kennedy Round. While the 1979 Act dealt with substantive law concerns, issues regarding procedural rights and remedies were largely left to another time. Congress then turned its attention to the Customs Courts Act of 1980 and access to judicial review, a concept critical to the protection of the substantive rights for all involved in customs and international trade law. The 1980 Act was designed to provide a comprehensive system for judicial review of civil actions arising out of import transactions affecting international trade. The key was to ensure that all who come before the court had full access to the judicial remedies in law and in equity available to litigants in other federal courts. It also eliminated the jurisdictional and remedial confusion that plagued both customs and international trade litigants for many years. As it emerged from its nascent years, the work of the court was growing in importance to the international trading community. Articles about customs and trade law were no longer relegated to trade journals or to 3 to 5 lines in one column on an inside page of the business section of a newspaper. Rather, customs and trade issues, including court decisions, began to appear in articles in national magazines and above the fold on the front page of major daily newspapers. As a young teen, intellectual property in the form of parallel imports and environmental law cases implicate the customs and trade laws and command the attention of the court. A decision of the court gains prominent attention as it affects the landscape of the automobile industry and the American consumer, specifically whether a Nissan Pathfinder is a car or a truck. One particular court decision becomes part of the lexicon of late-night television and the media, with jokes and commentary about G.I. Joe and whether he is a doll or an action figure, followed 13 years later by similar commentary about Wolverine and his celebrated cohorts, the X-Men. Judges grapple with complex multi-party, multi-issue mega cases affecting the American and worldwide steel industry. Customs and international trade law makes its way into law school curricula. Law reviews and journals focus on the decisional work of the court and critical issues in customs and international trade law. The interplay of the court's interpretation of the law and that of international trade dispute resolution panels is the subject of much debate and commentary, and decisions of the Court of International Trade in customs and trade law make their way to the Supreme Court for the first time in decades. The judges of the court undergo generational change, not once, but twice. With these changes come new ideas as to the approach and direction of the court. Technology starts to play an ever-increasing and important role at the court. With the advent of the court's case management electronic case files, CMECF system, changes the dynamics of practice before the court. Over the years, a wide array of products have dotted the landscape of the court's docket. Along with these products come weighty and challenging issues involving fully developed market economies to emerging economies, from state-owned industries to privatization, from state-influenced economies to state-directed economies, and from the constitutionality of the harbor maintenance tax to free speech and due process claims regarding the Byrd Amendment, otherwise known as the Continued Dumping and Subsidy Offset Act. The impact of the court's decisions is felt everywhere. While the court resolves individual disputes, its work is part of a larger construct, one that is dynamic and ever-changing, yet designed to provide predictability, certainty, and transparency to those engaged in international commerce. The court's work not only resonates for the parties involved in the particular litigation, but also at the agencies, Congress, and on the international stage at the WCO and the WTO. A few years ago, a longtime practitioner remarked that the Customs Courts Act of 1980 has stood the test of time. The essential purpose of that act is as valid today as it was 35 years ago: to provide persons adversely affected or aggrieved by agency actions arising out of import transactions with the same access to judicial review and judicial remedies as Congress has made available for persons aggrieved by actions of other agencies. Whatever the future may hold, whether in changes in international accords, changes in domestic law, or developments in agency practice, one thing is certain: a solid foundation exists for the resolution of customs and international trade disputes in the American jurisprudential arena. Ladies and gentlemen, thank you for your time and for your attention. I would be a tad remiss if I didn't mention something that has happened just the other day at the court. Some of you who are practitioners are aware of this. On Wednesday, the court lost one of its members suddenly and tragically. Senior Judge and former Chief Judge Donald C. Pogue, a son of the Midwest, passed away. I would ask that we just take a moment. Many of you may not have known Judge Pogue, and some of you may know him by virtue of his words and his decisions or articles that he may have written. Judge Pogue was a very important figure at the court, not only as a colleague, but for me personally over the years as I worked with him in the clerk's office. And I guess the best way that I could describe Judge Pogue is a quote that really reflects his philosophical soul and deep judicial thinking, as characterized by our host, Professor Colares. And this is Judge Pogue's words: "Life is a mystery, and it's important to talk about and think about the great human mysteries of life, death, and how we know what we know. And that ties into the law in the sense that we're all equal in the face of these questions. That is the perspective of the judiciary in a democracy, that understanding of equality is where you've got to start." And that sums up Judge Pogue as a person, as a judge, and as a human being. And so at this moment, I ask for a moment of silence to remember my dear friend. Thank you.
Thank you, Judge. So I'm Larry Friedman. I'm a partner at Barnes, Richardson & Colburn in Chicago. Good time to be in Cleveland. Good time to be a baseball fan. Good time to be from Chicago. I am thrilled to be here. I want to thank Professor Colares for the invitation. This is a particularly great invitation because my job here is now just to ask questions. I will be asking the judge some questions to sort of flesh out some of the thoughts that you already expressed and drill down, as we say, a little bit into your business at the court and what the court is responsible for doing for trade. So, Judge, you ready to?
Yeah, as soon as I can get this one thing to behave itself. Okay.
All right. So, obviously, the court is a court of limited jurisdiction, hearing, but it does have the responsibility for hearing and resolving a number of different types of cases. The largest groups of those are 1581C cases, so trade remedy cases, and 1581A cases, which are denied protest customs cases. So can you tell us a little bit about how the review of those two types of cases differs, maybe starting with the scope of review? So how are those cases, what's the scope of review for those cases?
They differ. Our typical customs case, a 1581A case, is a challenge to a decision by customs and over what's called a denied protest, which is the final act, administrative act by U.S. Customs, and that triggers the right to judicial review. That's on a de novo standard, and so the cases come to court, and the court makes a decision based upon the record presented to the court by the litigants, and the court decides the facts and the law de novo. Now, I should stop for 2 seconds just to say that 1581A cases make up the majority of new cases filed at the court every year. But 1581C cases, which are challenges to decisions by the U.S. Department of Commerce and the International Trade Commission on anti-dumping and countervailing duty, or subsidy cases and injury decisions by the ITC, while not making up the majority of the new cases, represent probably the majority, if not the majority, the plurality of day-to-day filings in the court. And the difference between the two cases is customs cases involve only two parties, the importer and the government, whereas the trade remedy cases involve multi-parties. In the trade remedy cases, the agencies are charged with making a decision based upon compiling an administrative record. And that record gets filed with the court, and the court then makes its decision based upon the record. The court does not take new evidence in those circumstances, and the court typically is looking at the record to see whether the factual findings by the agency are supported by substantial evidence and whether the legal questions are in accordance with law. There are two other standards that are typical of the Administrative Procedure Act review, which is arbitrary and capricious and abuse of discretion. And there are certain types of decisions that are rendered by the agencies that fall subject to those two more deferential standards.
So as a side there, you mentioned the Administrative Procedures Act, and I will say that for those of you who haven't taken administrative law as a plug, you should do so. If you're interested in this area of law, it is everything that we do at the court involves seeking judicial review of an agency action, although the APA is not directly relevant in all cases.
Right.
So, Professor, you agree with this on my plug for administrative law?
I not only agree with you, but I love you for making that point in front of my students, because it is what we have in the United States in terms of United States international trade law is the administrative law of international trade. And a professor can never emphasize that enough. And hearing from a judge, practitioner, and I hope our other panelists will emphasize the point kind of further. If people ignore what professors say, they shouldn't ignore what practitioners are doing. A quick question to the judge, just to give the audience a general perspective. Not unlike what happens with any determination on a matter of fact, the determination, the standard that you approach, the way you approach a determination on a customs duty is on a customs.
De novo, right.
It's de novo, which is very it's different when you're looking at what the Department of Commerce and the International Trade Commission have done.
Right. So let me try to make this a little bit, this abstractness a little bit more concrete. When we're dealing with a customs case, what the item is a question of fact. At the end of the day, in many of the customs cases, that is rarely a dispute among the parties. And so we don't end up with a lot of trials. We may end up with a lot of motions for summary judgment to which affidavits and the like are attached. The question of where that item fits within the harmonized tariff schedules of the United States, which are about yay thick and are about complex and as complicated as the Internal Revenue Code, but it operates on a hierarchical structure from, in essence, the less refined raw product all the way down to the most refined products. Where it fits, which provision applies to that merchandise to determine its tariff rate, that's a question of law. And so many of our customs cases are resolved by cross motions for summary judgment. Now, in the trade remedy cases, the agencies will make a finding of fact. And a la administrative law, what you learn from the case law is that the court, and from the statute, and Congress, when it drafted the Trade Agreements Act of 1979 and then the Customs Courts Act of 1980, engrafted many of the standards that you find in the Administrative Procedure Act in 5706, 5 U.S.C. 706, into the judicial review arena for the review of trade remedy decisions by the agencies. It doesn't have a pointer to 5706, but it uses virtually the identical language. So for this judge, I won't speak for any other judge, what that means based upon the Supreme Court teachings, and then the Federal Circuit teachings in the evolution of the CIT law, is that on findings of fact, right, it doesn't have to be the one and only one conclusion that the agency can come to based upon the entire record, but is that finding of fact reasonable, right? Then you shift over to matters of law, whether it's an interpretation of the statute or the regulation or a practice, and the court is also looking at the agency's interpretation, how it comports with the statute, is there a gap, et cetera, and that gets us into Chevron and Mead and Skidmore and our AUER, right? But again, this judge, speaking only for this judge, I use a reasonableness test, right? And you follow the rubrics from the Supreme Court teachings, and that drives that should drive the outcome. It's to a certain extent, it's a rules-based decision-making process. And again, the agency's interpretation, we'll just talk about it in terms of a statute, has to be reasonable. It has to comport with the statute. And for any of you who've taken administrative law, you know about Chevron. If the statute is clear, the agency must, right, follow the statute. If the statute's ambiguous or there's a gap, right, you give deference to the agency. And so when you're looking at this spectrum of standard of review, the least deferential standard is de novo, right, because the court's making the determination of fact and law in the first instance, all the way up to abuse of discretion, which is the most deferential. And as you move along that, you're really talking about degrees of reasonableness or unreasonableness, in leastwise in this judge's opinion.
So beyond the denied protest cases, the customs cases, and the trade remedies cases, the court hears other types of cases also come before it. Thought we could maybe just tick off quickly some of those. They take up, obviously, a smaller part of the docket. So can you tell us about trade adjustment assistance cases and what those are? And
trade adjustment assistance cases are involve displaced workers, in some instances displaced folks in the agriculture or aquaculture industries. And effectively, Congress passed legislation that provides these individuals with extended unemployment and retraining and potentially even relocation benefits based upon the fact that they lost their jobs as a result of an uptick in imports, and it doesn't have to be unfairly traded imports. It's fairly traded or unfairly traded imports, and they lost their jobs. They make application to the Department of Labor, or in certain circumstances, the Department of Agriculture. They go through an administrative process. The agency makes a decision, and if that decision is adverse, meaning the individual or the group of individuals who apply do not get what's called certified to be eligible for the benefits, which are administered in block grant programs by the states, they get the right, they get the right to come to court and challenge that decision. Congress a few years ago changed the law, and so the granting of trade adjustment assistance benefits is, I won't call it automatic, but the standards loosened up, and so the likelihood of the court seeing a challenge in this area has dropped off, because the way the law is administered now, more and more people are actually qualifying for certification.
And, sorry.
Just a quick thing. I was very pleased with the judge's description of the different ways the court approaches decisions by customs and decisions by the trade, the agencies charged with administering the trade remedy statutes. But it's also, I thought it was also important to mention, and perhaps we can talk about the ICTAS case, a recent decision by the court.
Right.
How the court also, being an Article III federal court, applies doctrines of procedure that the lawyers that are litigators that are used to litigating before the non-subject specific federal courts are used to. In particular, in the case involving the issue of what would be under the Federal Rules of Procedure Rule 82, that the notion that no particular, you cannot by rules of court bestow or withdraw jurisdiction, and how the issue in ICTAS came about, and how, in my opinion, it was masterfully dealt by the court and by you.
Well,
so if you could just expound on that so that people...
I'm not going to say all that much about ICTAS because the merits of the case are subject to litigation, but the opinion that Professor Collares is referring to is a procedural one. There was a motion to dismiss for lack of jurisdiction. Effectively, what happened here was that the plaintiff jumped the gun on the statute of limitations, because there's a gap period between the date of the final decision by the agency and publication in the Federal Register, and the statute says that the statute of limitations begins to run from the date of publication of the agency decision in the Federal Register. The plaintiff jumped the gun, and the question was, did the court have jurisdiction? I'll leave you to read the opinion. It's posted on the website, but the essence of what was before the court and what was involved in the opinion was the evolving standards from the Supreme Court about what is, quote, jurisdictional and what is not jurisdictional. And because we were dealing with a statute of limitations issue, we were talking about jurisdiction versus claims processing statutes. And the Supreme Court has spoken about what kinds of provisions are viewed as jurisdictional and set out a test for that, and what kinds of provisions in the law are, quote, claims processing. And the Supreme Court basically says if it's claims processing, it's not jurisdictional. And the ICTAS decision fleshes all of that out, and I came to the conclusion that we were dealing with a claims processing statute, not a jurisdictional statute, and the case is now moved on to the merits, and I'll say stay tuned, and whatever happens on appeal, if any, we'll find out, and whether I was right or wrong in my analysis, the Court of Appeals will tell me eventually. And they're right either because I got it wrong and they're right, or they're right because they're next in line. At the end of the day, I'm not sure it matters because, you know, they get the next word.
Just a message to my students. So First point, administrative law. Second point, civil procedure never leaves you. So,
Well, so maybe we talk a little bit more about civil procedure. I'm going to skip ahead a
Okay.
little bit if it's okay with you.
Do you just, you want to touch on the export, stuff in forfeiture and seizure or not? Or we'll come back?
We'll come back to that, but as long as we're on civil procedure. So the CIT operates on its own set of rules. They're not the federal rules of civil procedure, although they are very close. So, but there are differences that for folks who have taken federal civil procedure may find surprising in practice at the CIT. So maybe we talk about some of those. One of the fundamental concepts we all learn in our first or second year of law school is the notion of res judicata. You know, there's an end to litigation. Once an issue is decided, but at least with respect to customs cases, that's different. Can you explain the history of that and how that turns out in practice?
There's quite an old case called Stone and Downer. The rule of res judicata does not apply for the most part in CIT litigation, and most particularly in the area of customs litigation. And the principle behind that, enunciated in Stone and Downer, is that each and every entry of merchandise into the United States is viewed as its own separate transaction, which potentially can give rise to its own cause of action. So if you are ABC department store and you import glassware from Austria, and the question is whether it's blown glass or cut crystal, and you're importing it into 5 different ports in the United States, and let us assume for the sake of argument just one entry for each port, it is potential under the Stone and Downer approach that you could have 5 separate causes of action, right? And most times, most importers and their lawyers will file 5 separate causes of action. They won't necessarily bundle it, right? And so ostensibly what happens is you litigate one of the cases, depending upon which side of the V you're on, you're happy or unhappy with the outcome. Potentially you have the opportunity, if you have a different theory of the case, to relitigate it under the Stone and Downer approach. The thing is that you face a higher burden when you relitigate on the new theory. Does that fairly capture?
Yeah, I think as a practical matter, and this is just me opining here, but I think as a practical matter, you have a higher burden because you're likely to see the same judge. Judges have an interest in stare decisis. I mean, stare decisis applies even where res judicata doesn't. So there is a point where you can't just continue to raise the same issue with the same theory and not run into a problem with the judge. But procedurally, there's really nothing to prevent you from doing it.
And as a practical matter, I will tell you, in my 35 years at the court, I can count the number of times on one hand an importer plaintiff has relitigated an issue, maybe 2 hands. Different importers may have litigated issues that spur off it, but the actual classification of, imported glassware doesn't tend to come up in multiple litigations very, very often. I think the most famous one, Jim, you may have been at Stewart and Stewart at the time when they did the glass.
Shot optical glass.
Were you there? Yeah, shot optical is the one that stands out in my mind.
Shot optical is an interesting case to read. That's where I believe it was the Federal Circuit said, okay, we get it, res judicata, but stare decisis, and at some point there's going to be an end to this. You better have a new theory.
Now, at the end of the day, as a practical matter, what happens is these cases come in, the litigants choose one of the cases to be what's called a test case. The other cases get bundled behind that test case, and they get, our term of art, suspended. They're stayed. The test case gets litigated, testing the legal and factual principles involved. It goes all the way through the litigation process, including appeal, and then typically what happens is, we'll call it the parent and the child. The child cases get disposed of based upon the outcome of the parent case.
Is this possibly an example or an illustration of what when I teach CivPro, the very end we cover res judicata, issue preclusion, and what what I've observed over time, and other scholars that write on procedure have also noted, is this notion that as rules on issue preclusion become broader, right? For reasons of fairness, you want to craft exceptions, but these exceptions have been read over time in a very narrow way. Is this what happens in what you've seen happen? Although you may qualify under the Stone and Downer decision for an exception to res judicata, meaning you are allowed to relitigate, but the exception under which you come, judges tend to interpret that exception, or over time have interpreted it in a narrow way, or an increasingly narrow way. Do you see that?
Well, I can't remember the last time Stone and Downer arose in a decision at the court. There really hasn't been a lot written at the court in the last 10, 15 years about this.
Not as a controversy. I mean, I think the rule seems pretty well embedded in the court, and in the post-shot optical glass environment, I think it's just understood that it happens. There was a recent case, although there's some debate about how distinguishable the facts were, but the store wall case was, at least some people involved in that case believe, just a straight relitigation of an issue, and it just went to resolution. It happened to go to a different judge, happened to get a different result, which can happen. But I agree that I haven't seen a lot of controversy over Stone and Downer. Although I would tell the students, putting on my faculty hat, if you're looking for a law review article, take a look at Stone and Downer. It's a William Howard Taft opinion. Looking at it with fresh eyes, I don't know that it makes a lot of sense, but I don't have time to look into that.
One of the things in these customs cases is that in numerous instances, the importations in case number 2 or 3 or 4 or 5 don't necessarily line up identically with the importations in the test case. So I'm managing right now a settlement docket with many cases involving Home Depot, and the core issue had to deal with the importation of wall lamps, wall fixtures, wall lighting fixtures, and they come in all sorts of shapes and sizes and variations. While the legal principle may be the same, factually, those light fixtures are all different. There's 150 different models. And so the factual question is, does the models 123 through 135 line up the same way that the models did in the test case? And so you get this, where this is most likely to occur with a subsequent litigation is where the government and the importer plaintiff have a dispute as to how much the models line up. And so in that circumstance, you might well see a second case that's brought. It may go part of the way through litigation. The parties then end up in some fairly serious conversations, sometimes thrust upon them by the judge to talk about how these cases are similar or different. So that's the most likely context that you would see a Stone and Downer issue, I think.
I think related to that is the notion that as a CIT judge, you have, I think, an additional burden that maybe district court judges don't. No juries in these cases, so you're making the fact and law, the factual and legal determinations, and you have what's known as the Jarvis-Clark burden, which relates to what you're saying now about just getting it right. So what is that?
There was a case posted on the website called Jedwards, another one of my decisions. It was a classification case involving krill oil. I'm a little bit freer to talk about that one because the time has come and gone for appeal, so the decision is final. The plaintiffs imported the subject krill oil under one provision of the HTS. The government classified it under another. They protested. The case comes to court, and the plaintiff asserts a different classification. So in the classification dispute, typically what happens is the merchandise is liquidated at the rate determined by customs. The plainer importer is unhappy. They challenge it administratively, they get a denied protest, they come to court and they claim that it should be classified another way. Typically, that results, if the plaintiff wins, in a lower duty rate and a refund of monies. What happened in that case is under the Jarvis-Clark principle, which is a Federal Circuit decision which imposes an obligation on the trial court judge to find, quote, the correct classification. I decided that the government's liquidated classification was not appropriate, that the plaintiff's claimed classification was not appropriate, and I Jarvis-Clarked the case, and I had to find the correct classification, which, as it turned out, was the classification initially asserted by the importer plaintiff upon the importation of the merchandise. There aren't a lot of cases every year that are where the outcome is determined by Jarvis-Clark, but Jarvis-Clark is present in every single classification case before the court.
So I think I got to give due time to my colleagues from the trade bar before they all get mad at me. So let's talk about that. On the trade remedy side, you are much more often dealing with U.S. implementation of international accords, international agreements. And so I'm wondering how if you could explain how the fact that the U.S. statutes are the implementation of whether it's the Uruguay round or some subsequent WTO or the NAFTA or other agreement, how the international law and potentially how foreign law comes to play in the court.
Okay. Well, I think you have to start at a very basic level, understanding that the United States is a common law society, federalist society, where many other countries in the world are civil code societies. And you need to understand how international accords play into the U.S. Constitution. As you know, in civil code societies, if the country signs an international accord, that becomes part and parcel of the body of the domestic law of that country. It's not the way it works under our Constitution. International trade accords are just that. They're agreements. They are not viewed as self-executing treaties under the U.S. Constitution. So even though the United States is signatory to these accords, it requires implementation of those international accords by Congress. Congress can take the language word for word from the international accord. They do in a vast number of instances. And in other instances, they make adjustments in that language. And it becomes part of the U.S. Code. And so when the agencies are working on an international trade remedy dispute, which then ultimately may find its way to the courts, the agencies and the courts are dealing with the U.S. law that implements those international accords. And it may well be, whether it's in the statement of administrative action or legislative history, however you wish to describe it, there will be reference to and deference given to the international accord. But at base, the agencies are required, as are the courts, to deal with the interpretation and application and enforcement of U.S. law. And where U.S. law differs from the language of the international accord, the U.S. law takes precedence.
So let's try to figure out how to phrase this properly without getting you or me in trouble. Is it correct to say that there is a spectrum of judicial philosophy on the weight to be given the effort to remain harmonized and in accord with international jurisprudence, as there is with on the other end of the spectrum, a more laser-like focus on the domestic legislation.
Yeah, I think that's a fair statement, and it's not just, very candidly, the CIT's jurisdiction. I mean, there have been a number of commentaries about this issue, and it runs the gamut of whether it's a trade law or intellectual property. You know, there are some judges who view themselves as, I would say, more internationalist and trying to get their arms around things for international harmony or comedy's sake, and there are other judges who say, you know, my focus has to be on U.S. law. I'm aware of these things. I will take note of them, but I'm not bound by the International Court. I'm not bound by some international dispute resolution body determination. And yeah, I think it's a fair statement to say that there's a spectrum that's out there.
One question that I always cover in my international course, I typically begin with Charming Batsy, and I provide an example of an application of Charming Batsy in the Pillsbury case. Judge Pogue's.
What we should say, for those of you who have not read Charming Batsy, it's a Supreme Court case that basically says that international courts cannot trump U.S. domestic law.
Correct, absolutely. As fairly as possible, one should not interpret U.S. statutes in a way that creates, abrogates an obligation of the United States. However, in terms of the Uruguay Round Agreements Act, which is the U.S. statute, and my students should remember this, which is the U.S. statute that was brought to Congress, was basically, is the implementation of the Uruguay Round Agreements, sent by President Clinton in a statement of administrative action to Congress for an up or down vote pursuant to authority the president had to negotiate and conclude the Uruguay Round Agreements. There are specific provisions in the Uruguay Rounds Act that basically establish that WTO law does not have self-executing authority in the United States. And also, it's a separate issue, but it's important to highlight the importance that although there is a spectrum, the exception from Charming Batsy to the aspect that as fairly as possible, you shall not interpret a U.S. statute in a way that abrogates an international U.S. obligation. The statute goes out of its way to say that WTO law is not self-executing, right? And second, there is no private right of action, to sue under the URA, Uruguay Round Agreements Act. So Judge Gordon is absolutely correct to say that there is a spectrum. There's that some judges will give a greater persuasive, though never controlling, role to a particular provision of the WTO agreements that is being interpreted by the agencies under URA. Not the agencies don't apply WTO law; they apply national law. But the general tendency, at least in matters regarding URA, is a very deferential.
Right. Now, there is I guess for lack of a better description, there is a safety valve, and I think it's important to understand that when you're talking about a challenge to an interpretation or application or enforcement by the U.S. agencies of trade remedy laws, that involves private parties and the government, and that's what happens, the litigation before the court. If it turns out that the agency interpretation or a court decision, a country believes that conflicts with their understanding of the WTO agreements, then you get a country-to-country dispute resolution process at the WTO. And the law has a safety valve mechanism that if there is an adverse decision at the WTO, either by a dispute resolution panel or an appellate body, that the U.S. government has an opportunity to look at that and decide whether it wants to bring its domestic law into conformity, and then there's a whole administrative process that ends up potentially in a litigation before the court as that unfolds itself. So there are mechanisms in which to bring domestic law into conformity with the international understanding of a particular part of the accord.
But don't you all also end up with the possibility that your court and the Court of Appeals for the Federal Circuit has found a domestic implementation to be acceptable, to be consistent with the law, whereas an international body, whether it's a dispute settlement body or a NAFTA panel or some other panel, has found it to be inconsistent with the international agreement, in which case you then have obviously a conflict. And what happens in those circumstances, and how, if in any way, does that affect the court's jurisprudence?
I think I'm going to have to defer to Michelle or Dominic on that, but I believe that it ends up in country-to-country negotiations under the terms of the international accord. But at the end of the day, if the courts find the domestic law is fine until there's a change in the statute by Congress, that's what the law is, even though there may be a differing opinion by some international dispute resolution panel. But that's policy, right, which is driven at a very different level by the executive branch, and our focus is on what the U.S. law is, and we don't go there until Congress changes the law and tells us differently.
Yeah, the Title 16, Section 3632, I believe, establishes the mechanism for implementation of these decisions, as in the judge is absolutely correct. It leaves to policy to do that, and perhaps Michelle or Dominic want to add something to this.
All right, I want to move on, if that's okay. We'll talk a little bit about what I'll call the state of the court, if you're comfortable with that. So just so everybody knows, the court sits, I think, primarily for historical reasons in the city of New York.
Right.
But has jurisdiction over the entire country, unlike any other district level court. So can you just talk a little bit about the mechanisms, the rules, and the technology maybe that the court uses to manage a national footprint?
First and foremost, if a party for whatever reason needs the court to travel to any location in the country, either because there are witnesses there or it's more convenient for the litigants or the attorneys, a party just makes a request to the court.
I'm sorry, I have to interrupt. Can I cite you if you said for the attorneys? Because I've always been told it's not for the attorneys.
Well, listen, the court's made a conscious effort in its strategic planning process to try to accommodate the lawyers, particularly in larger trade remedy cases where you're talking about moving a judge and a law clerk and maybe one court staff person to Washington, D.C., and you've got 10, trade lawyers involved. We do borrow courtrooms from the Federal Circuit, and when we're on those occasions where we're on trial in a customs case and all the witnesses are located in Chicago or Los Angeles, the court will travel to those locales. For those of you who've been in practice of law for a long time and remember back in the days of paper and actually, before FedEx, so much paper moved around the country by certified mail return receipt request in order to give people the benefit of what was known as the mailbox rule, for those who, I guess, still teach the mailbox rule in civil procedure. But about 20 years ago, the federal court system embarked on a major technology effort called CMECF, and basically we built a robust database that captures all of the docket events in the life cycle of a case, and it has an internet-based portal for filing. And today, the CIT is among a handful of courts in which 100% of its docket, all public and confidential documents, are filed. And so it makes no difference, very candidly, where you are, not only in the United States, but in the world. My favorite story is there was a trade litigation going on. There was a sole practitioner who was in Southeast Asia visiting a client on another matter, And typically in the old environment, that would require a whole bunch of extensions of time, and maybe they would be trading briefs back and forth with their office via fax. That lawyer was able to sit in his hotel room and meet the filing deadline requirements in the particular case for filing their brief because they had an internet connection, they had a laptop, and they were able to write and edit their brief and file it on time. And as long as you have an internet connection, you have an ID and a password, you can get into the court system. It takes this concept of the clerk's office and the dockets being open and really makes it transparent, because as long as you can get into the system, you can look at any document in any case except those for which there's a protective order that keeps them confidential. And, you know, law firms used to send runners and would call the clerk's office to check on the status of things. And, you know, trade rags made a lot of money by sending folks to the court and literally pouring through docket sheet after docket sheet after docket sheet to update their records to keep the bar informed. Now, you know, you have a handheld smartphone and you can pretty much do anything you need to do with the court. We were one of the early district-type level courts. The bankruptcy courts were a few years ahead of us to have this system, and it's been pretty comprehensive for the last close to 20 years. And technology plays a very big part. I had a trial a couple of years ago. We have a technology courtroom. I had witnesses down in the border who did not speak English. It was going to be very costly to transport those witnesses. We did video conferencing. They were in a secure room at the border. They testified. There was a translator there and a translator in the witness box in New York, and we conducted a 4-day trial using technology. We have, with simultaneous translation and video conferencing, we have what's called an ELMO, which is an electronic evidence presentation system in the courthouse. We use teleconferencing quite frequently. So we try to take advantage of technology where we can to try to make the process more efficient and less costly for the litigants.
It's completely ruined my collection of frequent flyer miles. Probably we should have an opportunity to take some questions. Hopefully we have some questions. We have a little bit of time.
You need to pass the mic because this is being live recorded, so.
I don't bite, you know, so ask away. No question is too simple.
Is there an intersection of international patent disputes and international trade disputes?
In a very small window, where merchandise is imported and is then either excluded from entry or customs typically will take some action relative to the imported merchandise because there is a claim of patent infringement. It may give rise to that intersection, but it typically has to require an action by U.S. Customs for that to occur. We've had a handful of those cases over the last 15 or 20 years. I probably had the most recent one. It involved coaxial cable connectors. There was what's called a 337 decision by the International Trade Commission. There, the representation is that the imported merchandise is violating a U.S. patent. An administrative law judge and the commission make a decision about that, and what results is what's called either a limited or a general exclusion order, which is then enforced by U.S. Customs. And what happened in the case before me is it was enforced by U.S. Customs, and in enforcing it, U.S. Customs made a decision about the imported merchandise and whether it violated the patent that was the subject of the exclusion order. They then excluded the merchandise, the importer protested it, and then the protest was denied and it came before me. And I, in the context of deciding whether the exclusion was appropriate, was forced to conduct a patent analysis. Right. So Customs stepped into the shoes of the ITC and conducted its own patent analysis, and Therefore, so that served as the basis for the exclusion. It wasn't where Customs was wearing an administrative hat and enforcing the exclusion order issued by the agency. It actually made a substantive decision on its own as a result of the ITC's decision. That's typically the context where we will see intellectual property law litigation. There may be some other types of exclusions for copyright or trademark. Sometimes that involves textile goods where they're seconds or thirds or fourths, they're brought in, they're detained, which then administratively becomes an exclusion. There may be a parallel seizure and forfeiture case, which goes to the U.S. attorneys and the district courts, and then there's always this balancing act that takes place between the seizure and forfeiture action and the denied protest action that's at the Court of International Trade.
But is it fair to say that in all the cases that would come before you, there has to be a review of a federal agency that's the underlying cause of action? So there would not be an opportunity for a private commercial international patent dispute or other?
Correct. And 99 times out of 100, it's an action taken by Customs. And the real question is Customs acting on behalf of another agency, enforcing their order, or is Customs making its own substantive decision, which is then the subject of the litigation? That's always the challenge. Results in motions to dismiss, and so it's always interesting procedurally in those cases. Any follow-up on that? You got it? Okay.
We have time for one more question. We are about 5 minutes, running 5 minutes late, but we have a 15-minute break, now 10.
I don't mean to get too political, but in the past two presidential debates, Hillary Clinton mentioned she wants to have a trade prosecutor. How is that? Is that any different from what the system we have now? Like, who is prosecuting it on the side of the government? And do you think, would this change, would it be like a bigger mandate for the prosecutor or direction? Or?
I'm going to leave politics out of it. I think our next panel can talk about it a little bit in the context of some legislation that's been passed by Congress called the Enforce Act, and they'll be able to get into it a little bit better than I.
Are you guys going to talk about that Enforce Act stuff? They are now. Okay, so perfect.
There's one other question in the back of the room.
So you mentioned protectionism at sort of the beginning of your speech there, but I just was wondering how you see the potential for increased protectionism in coming administrations affecting the field.
Courts are reactive. We don't make policy. I have no way to know what's going to happen, and that's left for the executive and the legislative branch to decide. If they enact new federal statutes, our job is going to be to resolve what those statutes mean in the context of a litigation. The politics or the intent or the purpose behind it, that's for others to decide, and we react to it in the context of a particular litigation.
I'll just say, just as a political thing, candidates will say a lot of stuff, and then all of a sudden they'll figure out when they actually try and do something that we have agreements. We have tariff rate bindings. And there's also obviously the risk of retaliatory action by our trade partners. So there's a lot of rhetoric. What actually happens is a whole other thing.
The judges, we're bound to decide what comes before us. All judges, doesn't matter whether they're local judges, state court judges, federal judges, they all develop a judicial philosophy, and whether a judge is a free trader or a fair trader or a protectionist, it never comes up in a conversation around the lunch table. It's just not something that plays itself out. We're supposed to look at the law, and we're supposed to treat the litigants equally and fairly, and that's what we do. Thank you all very, very much. Appreciate it greatly.
We should come back at, how about 10:05?